Hi, everyone. Thank you for joining us. Good morning, good afternoon, good evening, wherever in the world you're joining us from. I'm Dr. Meagan Wong. I'm a lecturer at Essex Law School, where I'm the founding director of the LLM in International Law degree. And together with Dr. Emily Jones, we are the co-founders and co-conveners of the Public International Law lecture series. And we are so pleased to have you with us today. For those of you who are joining us for the first time, Dr. Jones and myself are pleased to present the Public International Law lecture series. And for those of you who are joining us who have attended our series before, we would like to welcome you back. Before we begin our event today, Dr. Jones and I would like to offer our condolences to the people of Turkey and Syria and take a moment to express our deep sorrow for the devastating events that are unfolding. And we would like to encourage everyone to support however they can, including by donating where possible to relief effort. So for today, I am your host for this event with our speaker, Dr. Tamsin Paige, who will be chaired by Dr. Emily Jones, and I will defer to Dr. Jones, our chair, to introduce our speaker today. As your host, I wanted to speak a little bit about the Public International Law lecture series. So this lecture series is built upon two important intellectual traditions of public international law: formalism and international legal practice, international legal theory, including post-colonial and feminist perspectives. The idea for this series stems very much first and foremost from our friendship and is inspired from our respect for each other's scholarship and research, as well as our days of teaching LLM public international law together. We're both generalist public international lawyers with several specialist interests, but we engage with international law from different approaches. I'm a formalist and Dr. Jones is a critical legal scholar. This series that we co-founded and co-convened together brings forward cutting-edge discussion in international law from varied and different frameworks, theory, and practice, and what we hope is something for everyone. Now, let me introduce Dr. Jones, our chair for this event. Dr. Emily Jones is a NUACT fellow based in Newcastle Law School, Newcastle University. She's a generalist public international lawyer whose interdisciplinary work combines theory and practice. Dr. Jones's work cuts across gender and international law, international environmental law, the international law of the sea, science, technology, and international law, gender and conflict, outer space law, and political economy, imperialism, and international law. Her monograph, Feminist Theory and International Law Post-Human Perspective, was recently published with Routledge's Glasshouse series. And can I please note and share the book launch is next Monday, so we have a chance to celebrate this wonderful accomplishment by my beautiful and amazing friend, Dr. Emily Jones. And now I will leave the event to Dr. Jones to chair, and yeah.
Fabulous. Thank you so much, Dr. Wong, as ever. It's a pleasure to be here with you today, as it always is. So without further ado, I want to get the show on the road and introduce our fantastic speaker for today, someone I'm very excited to have with us, which is, of course, Dr. Tamsin Phillipa Paige. So Dr. Paige is a senior lecturer with Deakin Law School in Australia. And her work is interdisciplinary in nature, using qualitative sociological methods to analyse international law. But of course, and as we're going to hear a little bit more about today, Dr. Paige also undertakes law and literature research, using popular fiction to examine social perceptions of the law. She has published very widely on an array of topics in international law, including, but this is just the start of her work, but including Somali piracy, decision-making at the UN Security Council, and conflict-based sexual violence, among many other topics. And an interesting fact in a former life, Dr. Paige was in fact a French-trained fine dining patissiere, which is a fact I very much enjoyed, and I'm very impressed by multiple skills that Dr. Paige has. Dr. Paige will, of course, be discussing the lecture is entitled The Importance of Storytelling to International Law. Just before we begin, a very brief note on the question and answer section, which we will have at the end. So I'll be asking Dr. Paige your questions at the end of her lecture. There's a little Q&A button at the bottom of your screen. It's got like two little chat bubbles. You can post questions in there anytime. So during the lecture, after the lecture, whenever they come to your mind, just put them in there. But please note that if you want to remain anonymous, there is a button to click to say, I want to ask this question anonymously. So if you don't click that, I'll probably read your name out. So do remember to put that if you don't want me to ask your question. But, you know, there's no such thing as a silly question, as we always say. So don't worry too much about adding your name, because hopefully everybody here is lovely. Anyway, enough with logistics. I know we're all eager to listen to our fantastic speaker today. So without further ado, Dr. Paige, over to you whenever you're ready. And thank you for being here with us.
Thanks so much, Emily and Megan. I'd like to start by acknowledging the Wurundjeri people of the Kulin Nations, the traditional owners whose stolen land I'm presenting from today, and I'd like to pay my respects to their elders, past and present. So, as we would have noted from the abstract, this is starting with the idea of, the starting point of this is the idea of the power of the better argument in law. So in 2003, Ian Johnstone, drawing on a long tradition of legal scholarship, wrote an article about the power of the better argument in security spaces, particularly with law, but I would suggest that it goes beyond security spaces and goes particularly in international law to how we deal with the law generally. This is an argument and a suggestion that sits well and easily with us as lawyers. Law, as we are all taught or were taught in law school or now teach in law school, is a discipline of argument. It is a discipline where we are expected to work out our argument and maximize the evidence and law and everything else that and precedent, etc., that supports our argument, and minimize as much as we can any of those things that undermine or weaken our argument. We are a discipline of argument, and I would say yes, but what we actually end up with within this framework is we are a discipline of storytelling. We don't tell arguments. We don't make arguments so much as we tell stories to convince. But Johnstone's hypothesis, which draws support and similarity from people like Marty Koskianemi, and in international relations theory, Shirley Scott's ideology of law theory, was essentially that the law is presented through an argument, and the law exists within an interpretive community, drawing on the work of Stanley Fish for this. And the interpretive community, which is the practitioners of international law being states and civil servants who practice in this area, but also the academic community, forming two separate but related interpretive communities, are able to understand what constitutes a good and a bad argument within international legal practice and international law discourse, with states therefore tending towards making good arguments and not making bad ones, even if the argument they're making constrains their actions in some way, with the belief being that that constraint of action is benefited by the stability of a system where we all know good and bad arguments, and it has stability and all of those other things. And it generates, where there has been consistent argumentation, expectation of consistent behavior. In this whole scenario and in the related theories around international law, because this also draws on indeterminants, ideas of laws, in international laws, indeterminants, where you can make arguments and we know what's good or bad. Law mostly acts as a foil to power politics. As Koskianemi phrased it, it's the gentle civilizer of nations. It restrains bold-faced power politics. In Shirley Scott's ideology of law theory, what we have is a competitive ideology where everyone maintains their subscription to the ideology itself for the long-term benefits of being in a stronger position within the same consistent ideological framework of how the world operates. And this is a relatively solid theory. It creates a pretty solid basis of how we understand what's being said when the US State Department gets up and explains the legal basis for its action in wherever, or arguments are made by the EU about various trade things. It's generally not a bad system of understanding this. However, I would suggest that understanding what we are doing here, not as argument and a better argument, we would be better served by understanding this process as storytelling. And the fact that what we actually accept here is not the power of the better argument that wins in international legal discourse, but is the better story that wins out and is accepted going forward. And so the basis for this is, I'm, among other things, for all of my sins, I'm a lawyer, but mostly I'm a sociologist. And generally speaking, what we know is, as part of sociology, when we look at the role of stories in understanding the world, is that consistently evidence and facts and data and all of these things are abstract. They are seen and understood by society as abstract notions. If you want to get people to understand a phenomena, you tell them a story that allows them to relate to that phenomena, that allows them to make real the idea through connection. And so expanding from this, there's also, and this is the basis for the monograph I'm finishing up at the moment, is you can understand a society by the stories it tells itself. The stories it tells itself is a window into understanding how society works. But the idea of stories being how we make sense of the world was actually, I personally think, best summed up in a work of fiction by Mira Grant, where she said, and I quote, "Horror movies are educational if you know how to pay attention to them. They tell you about social trends, about the things that people are afraid of," end quote. So how does this relate to the law? How do we understand this idea of storytelling to make real as a question of what we're doing within the law? And so for a demonstration of how legal argument is really better understood as storytelling, I'm actually going to turn to the editorial in the special issue around on the invasion of Ukraine by Russia that appeared in the American Journal of International Law late last year. So in this editorial, the editors of EJIL made an argument from their own framing that the invasion of Ukraine was an unprecedented and egregious rupture of the international legal order and the UN Charter era legal order. Now, I have no arguments with them over the fact that it was an egregious act of aggression and a breach of international law. That's not my point here. I completely agree with all of that. But what they then go on to say is they raise this comparison with the 2003 Iraq invasion. And they argue, or I would say tell a story about why, from their perspective, the Iraq invasion was not an egregious rupture or act of aggression completely out of step with the international legal order. Their first part of this notion was that the invasion of Ukraine was clearly to annex territory. The invasion of Iraq was not. It was, however, for regime change. So I disagree with them there, because regime change is quite often annexation by proxy anyway. But what they really, the main hinging of their position on this was the notion that the US and UK had gone through numerous recent Security Council procedures around the purported breaches of WMD requirements and inspection requirements, etc., by Iraq, and that gave their invasion a legitimacy. And so particularly they point to the Chapter 7 resolution that was Resolution 1441 on WMDs and Iraqi compliance with inspections. They also noted, and this was part of the US argument at the time, that the 1990 Security Council resolution was still live, and there was still a UN Security Council mandate regarding Iraq's military, etc., because that was settled by ceasefire rather than by complete peace treaty. So we have this, and those events did occur. There was a Chapter 7 resolution in Resolution 1441 around Iraqi inspection requirements and around weapons of mass destruction. And I'll say here, the editors did note that, yes, the invasion, looking at all the facts in hindsight, was clearly an illegal act of aggression by the US. I'm not saying that they're arguing that, but they're mitigating, I think, the seriousness of it to the international legal order through these suggestions. And what they're telling here is a pretty good story. They tie together a pretty coherent narrative that distinguishes the bold-faced aggression of Russia in Ukraine from what US and UK did in Iraq. And it's a pretty good story. And I don't know the editors of EJIL well. They may well believe all of it. The problem is that it's a fiction. And it relies on facts. But what they have done is made a truth claim based on some facts. But they have omitted swaths of evidence that completely undermines their truth claim and changes the context. This is what we do with storytelling. We present a narrative that supports our conclusion. What they've neglected to mention in this story that they've told in the editorial was that in Resolution 1441, three of the five permanent members rejected the possibility of the use of force to gain Iraqi compliance around weapons of mass destruction inspections. They also neglected to note that that position of rejecting any possibility of a use of force in Iraq by the Security Council continued in meeting 4726, where the US vetoed a resolution put forward by France, Russia, and China to declare the US and UK invasion of Iraq to be a threat to the peace. Now, the selectivity of the events presented as a truth claim about the nature of law and the nature of these breaches is telling of the nature of storytelling to international law. Sorry, I'm being distracted by a dog that's gotten a little excited. The editors of EJIL in this storytelling to minimize the significance of the American breach while simultaneously maximizing the egregiousness of the Russian breach without acknowledging that both were equally egregious in different ways, and quite possibly the lack of consequences for the US in 2003 created an environment where Russia felt empowered to engage in such a breach. They did this through selectivity of evidence and curation of evidence to tell a story as a fact claim or argument. And so this is where I would suggest that if we stop looking at what we're doing with international law and its indeterminacy, etc., and as argument generation, start looking at it as narrative storytelling, we'll get a lot greater insight into the structure of claims around international law. This moves me to the second part of this talk, and the other point I kind of hinted at in the abstract for the talk, which was that this narrative storytelling, when done in relation to security situations, actually renders the commission of war crimes inevitable. It undermines everything to do with EJIL and the law and renders the commission of war crimes by soldiers in the field to be an inevitable consequence rather than an aberration that we like to tell ourselves it is. So, and the reason for this is that the stories that are being told about international legal action in these theatres are not to one audience. They contain multiple audiences. And some of those audiences are the world at large, the external audience. But quite frequently, those audiences are the internal audience, the domestic constituency. And noting that there's been a lot of scholarship done on how the narrative that you use to justify and make your population content with going to war against a foreign power follows the same narrative structure as a fairy tale. And this is important. And so this was looked at in relation to both Iraq wars by Lakoff, but it's also been addressed in, was addressed in 1999 by Anne Orford in the European Journal of International Law. Judith Butler has talked about it in some of their work, as obliquely has Foucault. This is not a controversial statement, but essentially, to quote Lakoff, sorry, I haven't started the quote yet. So justifying a war requires a cast of characters, and that includes, and I quote, a villain, a victim, and a hero, noting that the victim and the hero may be the same person. So this is part of this narrative storytelling we have around justifying both the legality of a war, but the war itself to a population. So the first thing that we need in order to justify to a population that going to war is a good decision is we need a villain. We need a villain, and the villain in this narrative must be viciously evil. And their vicious evilness justifies a righteous decision to go to war to defeat them. Continuing from that, it's important that while the villain is capable of calculation and cunning, they are always amoral, vicious, often monstrous, and thus cannot be reasoned with. The cannot be reasoned with is essential in order to provide a framework that the enemy must be defeated rather than negotiated with and spoken down. It also sets up this idea of an other enemy, this inhuman other that must be fought. And we've seen this cut across cultures in justifying wars. It's not just a Western trope. It appeared in Japan and China. It has appeared in the Slavic countries. It's appeared in Western countries. It's across that. So building on this, we also need to have a victim. The victim exists as an innocent who the villain has committed some form of immoral wrongdoing that must be corrected. So going to Lakoff again, Lakoff noted in relation to the first Iraq war, the first attempts of the US government was to cast US industry as a victim of Iraqi villainy. And this was not accepted by the US population, he notes. And so then the narrative shifted. The victim was the Kuwaiti people who were victims of Iraqi aggression. And this is true, but it was how it was put to a populace to justify this as from a narrative of one of self-defense of US industry to a narrative of the US as righteous saviors of the Kuwaiti people. Going to Iraq in 2003, we once again see Iraq cast as the villain, but we see them cast as a villain in two separate lights. We see them portrayed as being in cahoots with Al-Qaeda, allowing the US people to see themselves as the victims of Iraqi villainy in there, but we also see the arguments that have been leveled around possession of WMDs, casting Americas as saviors to a region that is under perpetual threat from the villainy. We've also saw these narrative structures get used with Russia's invasion of Ukraine around Ukraine's behavior, which we know was false, but we know that that's false. But the audience there was also the domestic Russian audience who, from what we have, don't know that's false and don't know that any better there. We also saw Mussolini and Hitler frame World War II as a self-defense against the unreasonableness of the victors of World War I. And this was, they were forced to take up arms in doing so. Finally, this cast of characters requires a hero. The hero can either be a gathered collection of allies or a lone hero. And the hero, and this is really important, and in the narrative of selling a war to a population, is morally righteous and an honorable, usually masculine figure who, in the face of villainy, persists and achieves a glorious victory, restoring moral balance. And it's also really important that the hero is framed to be facing overwhelming odds, but also inevitably going to succeed because of both their heroic and virtuous nature, but also the inhuman, monstrous nature of the villain. We have lots of evidence showing that this, again, set of tropes of selling a war to a population cuts across cultures. And we've seen these elements of storytelling frame our legal response to justifying a war externally as well as internally. And so the crux of this, to my mind, is that as a result of these stories that we tell to justify wars, what we then have is that war crimes become inevitable. And war crimes become inevitable because of the positionality that the soldiers take within this story. Within this story, where you must have a victim, a villain, and a hero, and sometimes the hero and the victim are the same people, the soldiers who are being sent to this war that has been justified through all of these stories that are being told to justify it are positioned both internally within their own mind, but also within the broader social narrative as the heroes, as morally righteous, virtuous heroes, and saviors of society against this villainous evil. But what that does is twofold. First of all, because the enemy is a villainous, inhuman, monstrous evil, they're not human, they're not people. But when you combine that inhumanity with the internalized assumptions of moral righteousness and virtue and savior status of soldiers, what you have is an internal justification for any conduct being committed by these soldiers against the enemy as justified because of this narrative trope. We've seen this phenomenon play out, how this changes the worldview and warps the worldview of soldiers. anyone who's from Australia and followed any of the evidence in the Ben Roberts-Smith defamation trial and hearing the evidence that Ben Roberts-Smith gave about his own conduct can see that being in that position, being put in that position, changed and warped his entire worldview and perception to the point where he didn't even realize that what he was portraying as normal was really, really not normal and acceptable by society. We also have reports within Australia about how there has been, in all of the military training, incentivization of dehumanizing enemies to make it easier for soldiers to do their job. But what this does is it continues this perpetuation of war crimes, because it can't really be a crime if it's not committed against someone who you see as another person. So because of this, I would argue that battlefield war crimes are inevitable because of the stories we tell to justify going to war, both to the world through our legal storytelling, but also to our domestic populace through what is both a legal storytelling and a social political propaganda. The irony of this is that places like the ICC and other war crimes tribunals, they spend all of their time prosecuting mid-level perpetrators and talking about accountability. When we look at the structure of the crime of aggression in conjunction with head of state immunity, the people who bear the real culpability for the war itself and put these soldiers in this position where they will commit war crimes are shielded entirely by legal norms and immunity from any culpability of that decision. All right, thank you.
Fabulous. Thank you so much, Dr. Paige, for that really fascinating lecture. And I'm still thinking about that end point myself, actually. So I think quite a lot to process for our audience as well, and the complicity of international lawyers ultimately in war crimes and through those stories. So thank you. Yeah, so if you have any questions, do post them in the Q&A section, as I mentioned. But I have one that's come in from someone who's anonymous to start us off. So I'll ask that to you while everybody thinks of their questions. So this person asks, to what extent is the dominant story, i.e. the one most likely to win out, also a reflection of Eurocentrism and racism in international law? And do you think that that's the dominant underlying narrative, in your opinion, or is it something else? So we can get started with that one, if that's okay, Dr. Paige.
No, that's fine. That's great. So the answer is yes. The dominant narrative is entirely one of Eurocentrism and imperialism and racism that comes with this. And there's a whole bunch of history there, but this is where Europe conquered the world and enforced its order. And so we teach in the norms of international law, when we teach people the form of international law, we teach them the narrative structure that is a better argument, that we call a better argument, but what we're actually teaching is the better narrative structure. And there's a minimization of the harms of that. There's a minimization of the fact that in the immediate post-Napoleonic War period, the line between British imperial law and international law was non-existent because no one questioned it because of fear of the reprisal from the British Royal Navy. We haven't undone that Eurocentrism as the acceptable narrative of law in that. You just have to look at, and I remember from a presentation that Douglas Guilfoyle gave around the Chagos Archipelago at ANZIL in 2019, where he brought up some of the late James Crawford's statements, where Crawford, in all of his narrative storytelling before the court, before the tribunal, I think it was a tribunal that this was related to, spoke about structured the argument in the form and reference to Greek mythology, which is often referred to as the cauldron of Western civilization. The reference and call to Catholicism and even various Protestant narratives of the world and morality in how we understand and define international law is prevalent. So yes, it's entirely grounded within telling that story. I mean, the best example I have was actually occurred in 1963 in the Security Council, where this started with a dispute between Portugal with their territories in Portuguese Guinea and Senegal over Portuguese decolonization, where there'd been some border incursions, there'd been a whole bunch of stuff, and the Security Council, made up predominantly of Western powers, said, look, it's not for us to set a timeline for decolonization. A few years later, about 40 African states came back to the Security Council, said, you need to help us here. We need Portugal out of Africa. And the Security Council said, well, it's not really a serious enough threat to warrant Security Council intervention. And the representative for Cote d'Ivoire got up and said, is this a question of body count? Because if it's a question of body count, tell us how many and we can make that happen. And the British ambassador to the Security Council clutched his pearls and said, he who comes to the court of equity seeking relief must come with clean hands. How dare you suggest that you can make us intervene if you just start killing people? And so, yeah, that whole narrative of what is serious and how do you make something serious was a requirement of Africa to conform to British perception. So, yeah, this is still prevalent. I hope that answers your question.
Yeah, I think it answers the question very comprehensively. So thank you. And I see it's inspired a few more questions from our audience as well. But I'm trying to, go with a variety of different topics with the questions. We've got lots that are coming in. So I wanted to now ask a question that's come in from Antoine de Spegliere. I probably said that wrong. I apologize, Antoine. But thank you for the talk. I wonder if you could say something about how you incorporate insights from non-legal fields, such as narrative theory, literary studies, etc., into your research, and the dangers that such interdisciplinarity can create, if any.
Okay, so I'm a trained sociologist. I'm a fully trained sociologist. I'm also a fully trained lawyer. And my work, while it's always been in grad school, I was in law schools and everything else, my work has always been sociological study of the law. So that's how I integrate it. I actually see what I do as not so much interdisciplinary, but hardcore sociology with law as my subject matter. I just have the advantage of, because I'm a trained lawyer, I know how to communicate that to lawyers. And unlike most sociologists studying the law, I know how to actually interpret what the law is doing because I've been trained in those forms. Whereas most sociologists I know who deal with the law live in fear of getting a review back that says, this is all interesting, but your law's entirely wrong. And it happens all the time. I have seen plenty of papers that do that in the same way that I see plenty of papers from lawyers and plenty of work from lawyers that are like, I'm going to be interdisciplinary. I've picked up this method from this field over here, and I'm going to integrate it into law without any understanding of the history of the method, the context the method was developed in, the goals of the method, or any of those things. And so the pitfall of interdisciplinary work from my point of view is most people doing it are not adequately trained in both the disciplines they're working in. And so how do you do good interdisciplinary work? You take the time to be fully trained and fluent in both disciplines. And it takes longer, it's much harder, you're keeping up with twice as much literature, but it's worth it in my mind. But yeah, don't be those people who cherry pick methods from other disciplines without understanding them, because invariably 9 times out of 10, if I ever get those ones to review, I end up having to say recommend, reject, because the data is wrong and invalid or whatever. Like it's awful when you can see there's a great idea, but there's a complete misunderstanding of how what they're doing is supposed to operate, and it's just been absorbed into their legal idea.
Thank you. Yeah, I would say, yeah, interdisciplinary work is a lot more work and quite a scary thing to do, but you know you've done it very well, so that's always good. But I want to actually ask now, we have two people that have kind of related questions, so I wanted to ask these two together. So the first one comes in from Kobe Lines, who asks, how does the victor's storytelling play into your theory? And what about if the non-victims, such as in Shagos, to your point, got to speak more or set the narrative? And says, I'm thinking particularly about Dr. Emma Nyan's work in this area about those most affected in international law very rarely have a voice. And this leads on quite nicely to a question from Rick Valders, who asks, would you consider that this dynamic of narrative is responsible for the state-centricness of international law instead of people-centric system, as people don't have the same power as states to shape these narratives? So I guess a question around, yeah, how can we, you know, what is the problem here? Is it because we're not hearing from the right people, and how can we hear from those people?
Okay, so yeah, I'll start with the question of victims and the people most affected. And yes, so the problem we have with people most affected is the people making decisions and shaping the narrative generally just see them as data. They don't actually speak to them. They don't actually get to know the story. So their story is not real. Their suffering is not real. It's just data. You know, for the average decision maker in a bureaucratic organization, casualties of an invasion or of a whatever, that's a data point. They literally, from a sociological perspective, they literally can't comprehend that as people. That's a whole bunch of coping mechanisms. It's because it's too big and it can't be made personal. There's lots of reasons for that. That's not a criticism. It's just kind of noting that these things are being done by data. So the people who are most affected, as you said, don't have a platform to tell the story, to have a voice. And we can see that in the difference where someone prominent is personally affected and they get to talk about it, because then suddenly everyone cares. When someone goes off and tries to tells these stories to people, people start caring because they have a personal connection somehow to the story. So I think, yes, part of this is that the people who are most affected either can't talk because they don't have capacity anymore because they're no longer with us, or they don't have access to who tells the story to then make the story known and make the hardship and the suffering personal. So, and I think that's not just an international law problem, that's a law problem, generally. So yes, we have, this is a huge problem of those people don't have any power to shape a narrative of how we respond and how we view a set of events, because any recounting of events is always a curated set of facts rather than an unvarnished truth. And it's curated facts presented as a truth claim. But people are going to leave things out that diminish the validity of their position or the validity of their actions. They're telling a story. And so victims don't have an ability to influence that. And if you're a state who wants to go to war, you're going to minimize the fact that your army is going out there and leveling civilian villages, because that's a really bad story to tell to your own constituents. And that's wrong, not supporting that, but that's what happens. But the people who are being harmed in those villages have no ability to tell a counter narrative. So yes, I think that question of who is the victim and who gets to speak really does shape how we view these issues. And I think that does go to the state-centricness of international law. I think there's a few reasons for that. I mean, first reason for that is, the centuries of colonial conquest, where literally the domestic narrative was one of white saviorhood to these places and bringing civilization, which utter shite. But that's the narrative that got told, and because it was happening all the way over there, that's what people believed. So it kept getting supported, and that's then states, it cemented through that conquest the Eurocentric and therefore state-centric nature of international law. And I don't have a solution for that. I'm not necessarily supportive of it. It's just what I can see of it. I hope that answers your question.
Great, thank you, Dr. Paige. Yeah, I think we're getting quite a few comments from people who also do interdisciplinary work talking about how, not hearing from kind of the marginalized voices is a problem of course, not only in international law, but, all the disciplines, and how this kind of resonates with them as well. And kind of on that note of interdisciplinarity as well, I wanted to ask this question from Tanya Attilano, who asks, as legal historians or legal practitioners in general, are there any methods to detect or find the storytelling within the legal argument? So do you have any tips on how people can also find these stories?
I think the one thing about you that you see in legal argument is that it's always very neat. It's always very neat. And particularly where people have information that they can't omit entirely, but it's really bad for their narrative, where do they put it? They bury it in a discursive footnote surrounded by dense references. So it's there, but you don't see it. It's one of those things that when an argument looks incredibly neat, and it's an argument that is bound to be contested, particularly around legal history and things like that, when the history is too neat, there's curation going on there. It may not be intentional, it may not be malicious, but there's curation going on there, particularly since all the historians I know sit there and say, yeah, history is a discipline of storytelling. We tell stories. That's what we do as historians. So I think when the facts are being presented in a manner that is neat, when everything is just so, and doesn't have a roughness to it, doesn't have any clear, yeah, but kind of points in it, that for me is when it's like, oh, you are covering something up with this story, my dear, is my response to when I read things that are just too neat. That's my kind of own internal one from doing a lot of this sort of stuff, is when something is just seems too neat, too perfect, too curated. That's when it's time to go digging, and I start with the footnotes. And if the footnotes don't give anything up, then I start with looking at other narratives, other papers on the same issue to see where the counterpoints are in it, and to see who's leaving what bits of what archives out particularly.
Yeah, interesting. So look for the stories that aren't complex enough in a way, because there's always complexity in every story in the end. So I wanted to now pick up on a couple of questions together because I think they're a little bit related. So the first one comes in from Rizwanul Islam, who asks, what could we do to hear from the others of international law, i.e. the less represented ones? And this, I think, kind of leads into another question from Kobe Lyons, who, again, thanks you for your fabulous presentation, and says that you framed the problem wonderfully, but what is in your opinion, is the solution? And I kind of wanted to add to this myself and ask you, how can we, if we know that international law is based on stories, it's based on kind of narrative, then how can we use that in a disruptive way? So questions around what to do next, I guess.
Okay, so what was the first question there? I lost them in the conversation.
First
Sorry.
one is, how can we hear from the others of international law? So I guess, you know, a solution to that specific issue. Yeah.
Yeah. Okay. So, I mean, at an individual level, it means being open to hearing from people who are from different theoretical frameworks from you, from the non-dominant narrative, being willing to listen to voices that might not be as polished, but are from different backgrounds. So, you know, listening to the scholars who can't get visas to show up to the European conferences, reading their work. I found Twitter to be really helpful for me in discovering who these people are and being able to read their work and things like that. But who knows what's going to happen to Twitter? But actively seeking out, even if they don't have the citation count, even if they don't have the whatever that you need to establish an easy citation, actively seeking in your citation practice to cite these voices and not just cite the usual suspects. I mean, it's really easy to cite Crawford. It's really easy to cite Orford. It's really easy to cite Koskianemi. It is. It just is. It's much less easy to, for instance, cite Owizo, who's, you know, a great African scholar. It's much less easy to cite. That's what I mean. So it's a case of actively do what you can from your position to seek out those voices and elevate them. Would be about what I say, but from the people who are on the margins, who don't have any voice. So the victims of these atrocities, the people on the field who are just people who are being affected by this and have no voice whatsoever. I don't have a solution for that. I've never been able to get funding approval to go and talk to them. No one wants to give me the funding I need to go and talk to them. It's always seen as not viable or not a priority for government or whatever. And I don't have a solution, and I hate that. But yeah, I don't have a solution for that. So, to Kobe's question, and I suppose your other question, Emily, around how do we use this narrative? How do we use this narrative tool of international law and tell a different story? That's like, most of us here are academics. Most of us here or we're practitioners. Tell a different story. Present the counter narrative. Even if it's not a long form journal article, Opinio Juris and all the other international law blogs always need content. Write the counter narrative, make it compelling. And that's the point of thing. Like, I've got a colleague who's a barrister, and every time she's writing academic work and sends it to me to feedback, I'm like, I have to sit there and go, take off your barrister hat, put on your academic hat. Academics don't care about your client. They care about the point of law that your client's case represents. And so it's about telling a story it's about knowing your audience as well. So academics, we do care about people, but you need to kind of use that hook and then move on to, and here is why this matters for the law, and tell the story about that. And they can work on the law, because people are abstractions for academics, because we're weirdos. And lawyers generally are taught not to be people. They're taught to be we're taught to be lawyers. And we know that we start thinking like a lawyer when we're sitting down in law school in the pub with a friend who's complaining about a really awful week they have, and we're sitting there nodding, going, yeah, you've got a cause of action there, maybe a cause of action on that one. That instead of going, wow, that's a really terrible week, how can I help? And so there's also a whole bunch of make the problem personable and relatable, but also tell people why it matters. So tell the narrative that makes it relatable, that makes people care, but also give them a why it matters and propose solutions where you can, but mostly tell the counter narrative. The counter narrative is really important, because people people will just believe the narrative that they hear that resonates the most with them. And as you know, it was said to me yesterday by a friend, it's hard to hate people when you know people. And so tell the narrative that makes it personal. And that was, yeah, so that would be how we can use this storytelling. Acknowledge that we're not trying to make a better argument than the people we disagree with. We're trying to tell a better story. Because by telling a better story, we don't win points in debating. What we do is we win hearts and minds. People care if you tell the better story.
Thank you. Yeah, I think that's a really nice note. I'm aware of the time as well to kind of end on, because it's very, it's inspirational. We can kind of all go off and tell different stories, and that's one way of being really disruptive. So I'm going to kind of use that to think about the rest of my week, I think. So I'm afraid we are out of time. I can see more questions coming in and more people want to join, but we do have to end at some point. So I'm sure you can email Dr. Paige if you have follow-up questions though, as well. But thank you, Dr. Paige, for joining us, and thank you to our fantastic audience for those questions as well. And Dr. Wong, would you like to say some closing remarks?
Yeah, well, thank you so much, Dr. Paige, for your lecture, for joining us, for sharing your thoughts, and of course, to my wonderful co-founder and co-convener, Dr. Jones. As always, excellent sharing, and it's always just, such a great time together with you. So thank you everyone for joining us, and have a good evening, good day, good week ahead.
Thanks so much.
Thank you very much, everyone. Have a good day. Bye.
Bye.